Back with the India Development Debate on ET now, and joining us is a very special guest, live and exclusive from London, Harish Salve. Mr. Salve, really appreciate you taking the time and joining us with your perspective on this. It's an over 200-page report, and we've struggled to go through all the pages, so I can imagine someone as busy as you would have not had the time to go through it. But based on what you've seen so far, read so far and heard so far, would you say that this is a strong data protection bill and a good start for India?
I've seen about the first, skim through the first 20 pages of the report. And the whole point which this report captures, to me as a lawyer, it changes the paradigm of the relationship between the service providers and the customers. What we had heard in the Supreme Court when we brought the matter up was a strong argument by Mr. Sibal that it's the relationship, for example, between WhatsApp and a customer is a purely private relationship. Don't want it, don't take it. And somebody, I think, who's appearing, I think, for Facebook, used the same arrogant tone. Don't want it, don't take it. I think this data protection law, which brings in constitutional precepts, brings in the law to the constitutional right to privacy, raises this relationship to what we as lawyers call the fiduciary level. So it's no longer contractual, it is a fiduciary relationship in which the service provider has a great duty of care. And once you change this paradigm, then everything falls in place when it comes to data protection. Be it the government, be it a private person, when you receive information on promise that you will keep it sacred, you will keep it private, and secondly, merely because you are providing a service, can you impose terms and conditions inconsistent with the constitutional right to privacy? These were the issues, and I think this report squarely answers them. It says you have to cast a strong duty of care on those who want to enter into this space and provide service, be it the government, be it private agencies.
The framework, Mr. Salve, goes into some detail on consent, stating it should be free, informed, specific and capable of being withdrawn. While that is positive, do you think the framework should have had more on the limits of consent, especially surveillance mechanisms by the government? And that's a concern that some people are pointing out.
You must also understand governments operate at two levels. Surveillance by the government as a part of law enforcement, as a part of security of state, does not require consent of a citizen. It's a part of what we, on a global level, what we call the police powers of a state. Every state has not the power, but the duty to protect all citizens. And if in achieving that duty, it has to, in exercising its police powers, it has to take certain steps such as tapping phones or looking into messages. Well, that's qualitatively something which is different and which has to be dealt with separately. So I somehow feel many times this debate blurs these lines. We are dealing with an area which falls outside the area of legitimate surveillance. What is legitimate surveillance? And in India, there is a huge gap where surveillance rules are thrown to the winds. And we unfortunately have become a society which is like the lynch mob. When the Radia tapes brought out the complete breach of all norms of how surveillance is to be exercised, we looked the other way because we thought the stuff which came out through the Radia tape was so juicy, so salacious, it needed to be discussed. Of course, the investigation brought out a big zero at the end. But everybody had a good time gossiping about who said who, what about whom. So that is one area which is outside, I suppose, the remit of this report. How should police powers be exercised and what should be the checks and balances, and more importantly, what should be the accountability of those who break the rules on which surveillance is to be exercised? I think this data protection law is more about service providers and the users of those services, the social media or other communication service, or people who, for various reasons, share personal data.
Sure. The other aspect, Mr. Salve, was on data localization. While it has given a nuanced approach on how some data sets should be stored only in India and others abroad, the devil perhaps lies in the detail here, because they've said that there should be a copy of every data set stored in India too, even when it's abroad. Now, a lot of people are wondering, how are companies big and small going to execute this? Even the GDPR in the UK doesn't have such a stringent provision.
See, the object behind the report is perfectly laudable. What we have seen in recent times about the revelations of how Facebook data was treated, with what absolute disdain for people's privacy these big, large companies have been operating, it does give rise to a apprehension that if data is not kept within the country, tomorrow you need data, you turn around and you ask these people for verification of the data, they say, sorry, it's not there, and you have no way of enforcing your laws. Because believe me, today, even the principles of what we call private international law, that means which rule of law, which principles of law apply to which activity and which entity, have not yet caught up with the virtual world. I mean, we used to believe those days that the law, if an asset is concerned, the law where the asset is situated will apply. Where a publication is concerned, the law of the place of publication will apply. Now, you put a blog on the internet, it's published all over the world. Now, which country was going to govern that? So, in order to give some sort of what is called a jurisdictional hook to how you deal with data, I suppose these kind of measures are necessary. Can they be achieved? I'm just about superficially familiar with the working of computers. I know as much as I need to know about using them for my work. Beyond that, I have no idea.
I take that point. Mr. Salve, what do you make of the amendment suggested on Aadhaar? The report has acknowledged the wide scope of Aadhaar and has called for a regulatory framework. Should we interpret this as some sort of a division of power between the UIDAI and a regulator above the UIDAI who will administer breaches, leaks, etc., which has been a concern of a lot of citizens?
See, today there is one of the concerns which has been expressed. I mean, if I may say so on a somewhat lighter note, I was delighted in the first 10, 20 pages of the report to see references to jurists like Ronald Dworkin, like Vaz. These are the liberal thought jurists in constitutional law, and I'm a great fan of this kind of thinking. So, anything which is government-centric is looked at with some degree of concern. So if the report suggests that Aadhaar also should be subject to some regulation, because ultimately Aadhaar is Government of India, I think it is something we should look at carefully. Don't look at it as a turf war. Think of improving what we have, rather than considering this, and I'm sure some people will jump to the conclusion saying, yes, see, our point is made, we are vindicated when we criticize Aadhaar. Nothing of the sort. These ideas evolve, principles of protection evolve, principles of constitutionality evolve. So this is not a criticism, it's an idea which one should consider. And I think to start by discussing it as a sort of a turf divide as to will the UIDAI come under somebody else, will somebody else have the right to call the shots? Don't make it so completely divisive. Don't reduce the discussion to so completely adversarial.
Okay, I take that point, Mr. Salve, but here's another question, and I think you are probably best equipped to answer this, which is, how is all of this going to play out practically? You know, we have a data processing authority now, or we will have, which will regulate data, but we also have sectoral regulators. So who will set limits on where jurisdiction begins and where it ends?
I think there will be overlaps, and the Supreme Court will draw the lines. I'll give you an example. Recently, I argued a case, and the question was whether if one telecom company makes complaints against another telecom company saying it was denying it interconnect, it's in public domain, so everybody knows about it. Who is the last authority? Is it the Telegraph Regulatory Authority of India, or is it the Competition Commission of India? Is it both? Are the areas divided? Are the areas overlapping? We have these kind of problems day in and day out. So if there are these kind of problems which arise in the working of the legislation, the courts will iron them out, and their overlapping powers are never by themselves criticized. As long as there is some way by which the authorities will work out for themselves as to when one authority will work and in what area the other authority will work. See, in India, we have to learn the art of working cohesively. We have a problem in India. Authorities tend to become insular. They tend to become turf-oriented. We have to learn the art of all working together, and we will get there, I'm sure.
Two last questions, Mr. Salve. One, would you say, in sense, based on what you've read, this is a middle path approach between the free market US and the stringent EU norms, the GDPR as well? So, would you say, in some sense, a middle path has been drawn? Nandan Nilekani joined us a little while ago, and that was his assessment as well.
Honestly, I haven't studied the report in such granular detail so as to be able to say whether it has gone short of the GDPR, whether it is of the same level, whether it's a middle path. I think Justice Srikrishna is a great thinker, and he must have tried putting all these restrictions in an Indian context. Are we ready for imposing the kind of limits which Europe can with its financial strength, with its technological strength? We may not be ready for that degree of rigidity. Secondly, the governance in Europe is far more evolved, is far more mature as compared to Indian governance. You given too much for regulation in India and you'll kill the baby.
Mm-hmm. Fair point. Last question then, Mr. Salve. The AP Shah Committee report, also on the issue of data privacy, just died as a report. We had Nandan Nilekani again lamenting the fact that he wrote on the need for a data privacy framework in 2010. A report happened and then nothing happened at the end of it. Are you more optimistic that the Srikrishna Committee report will indeed become law and the lawmakers will take it through the logical conclusion?
There is a commitment by the government to the Supreme Court. You know that young man who filed that petition in the court, which I had the privilege of appearing in twice, where the government has given a commitment that they are bringing a data protection law. And that is why the court has held back. So I'm sure now the government has to deliver on this. And I haven't read the report in full, but Justice Srikrishna is the kind of person who I would praise his report even without reading it. That's the kind of faith I have in him.
On that optimistic note, can't thank you enough, Mr. Salve, for taking time out and joining us with your perspective on what really is a landmark moment for India as we set the framework for a data privacy law in this country. Completely timed out on this edition of the India Development Debate. News and updates continue on the other side. Up next is Top 10 at 10 with Tanya. Keep it with ET now. Good night.